Good morning, good afternoon, good evening, depending on where you are in the world. And welcome to the ACC Foundation webcast, Managing Third-Party Risk, Universal Questions to Ask to protect privacy and security in a global environment. This session will outline key privacy and security due diligence questions to ask vendors and will highlight necessary privacy and data security terms that should be incorporated into third-party agreements. First, I would like to thank our sponsor, Finnegan, for making this webcast possible. Finnegan is a longtime sponsorship partner of the ACC Foundation. We are grateful for their continued support and all the amazing things we've done and will continue to do across the legal profession, from advancing diversity to informing and equipping lawyers around cybersecurity. Secondly, we will have time at the end for Q&A, so please feel free to enter your questions in the Q&A module on your screen, and we will field them as time permits at the end of the webinar. Without further ado, I'm pleased to introduce Lynn Parker Dupree, partner at Finnegan, who will kick us off. Lynn, the floor is yours.
Thank you very much. Again, I'm Lynn Parker Dupree. I'm a partner and the privacy practice lead at Finnegan. Finnegan is an intellectual property firm that does intellectual property and intellectual property adjacent legal work, privacy, advertising, trademarks being some of the areas that we also do in addition to patents. I'd like to turn it over to my co-presenter, Mark.
Good morning. My name is Mark Allen, and I am a Senior Director in the Legal Department at the American Lebanese Syrian Associated Charities, which is the primary fundraising arm of St. Jude Children's Research Hospital. Hopefully everyone knows what St. Jude Children's Research Hospital does. We take care of lots of sick children, and we appreciate all the support that all of the folks around the country and the world do to support the children of St. Jude. I'm here to talk about privacy and privacy security questions in a global environment. I'm a privacy specialist certified by the IAPP and the Tennessee Supreme Court, and privacy law is what I do. So I look forward to working with you, Lynn.
Thank you. So today I just wanted to sort of give you an overview of what we're going to discuss. As the title suggests, they're going to be universal questions to ask to protect privacy and security in a global environment. And we're really going to take you through the entire life cycle of the relationship, as well as focus on some contractual considerations required by law. As the world has increased in data, creation, the laws have become more sophisticated in an attempt to keep up with the reality of the data flows around the world, that data is created at a rate that, quite frankly, wasn't contemplated when I first started practicing privacy. So Mark, I wanted to ask you, what are some of the trends you're seeing in the law that really should inform how we are all viewing our relationships with our vendors and our other third parties?
Thanks, Lynn. That's a great question. There's been, as the slides indicate, there's been an increase in new privacy laws and cybersecurity requirements to help prevent and mitigate third-party risk. We see that pretty constantly happening nowadays. Historically, privacy laws are focused on business processes, but the new laws also create requirements that impact the way contracts should be drafted. For example, the new Colorado statute that took effect July 1, 2023, specifically sets out provisions that a processor must be governed by in the relationship with a controller. And some of those are, for example, now you have to have, in Colorado at least, you have to have processing instructions to which the processor is bound. You have to identify in the contract the type of personal data subject to processing and the duration of the processing. At the choice of the controller, the processor has to delete and return all personal data. The processor has to make available any information that's necessary for the controller to comply with the statutes. And very, very importantly, the processor there has to be a provision in the contract that requires a processor to implement appropriate technical and organizational measures to ensure a level of security. So as you can tell, this historical focus on business processes has been expanded substantially to require cybersecurity requirements, as well as how data will be processed, how long, when, and by whom. These changes are likely driven by the recognition that a significant portion of privacy and cybersecurity risk for organizations exists not in what the particular company is doing, as it was in the past, but also in the relationship with vendors, contractors, and service providers, essentially third parties who access or process data on the company's behalf. That is what at least one legislature in Colorado wanted to do. As Lynn will talk about later on, that's also what the legislature in California has done and other places. So Lynn, let me ask you this question. When you think about the life cycle of a relationship with a vendor, what are some of the most important things to consider?
One of the most important things that I think you have to think about is the relationship all the way from the very beginning through its conclusion. I think what I see very often is people sort of skip straight to like the term negotiation phase. You're right into like, what do I want in the contract? But what you really should begin with is like that publicly available due diligence before you even engage that third party. That you're going to be drafting then those risk-based contract terms, as well as, add those terms that are going to allow you to comply with the specific laws governing contract formations that we've begun to see developing the law. And then something that is very important that I feel like is often overlooked is how to properly conclude the relationship, really by defining how data is handled at the end of a relationship, how that data is returned. But it really is before you even engage all the way through the end of the life cycle, that is really important to consider. And the reason why I think that is because we've got to manage risk throughout the life cycle of a vendor relationship. And since you know a lot about that, can you talk a little bit about some of the questions that you should be considering and asking during the search and solicitation phase, even before we get to sort of the heart of what we think of as an engagement with a third party?
Thanks, Lynn. I'd be happy to. Well, the risk each vendor or service provider poses necessarily varies based on the level of information and access you're providing them. Factors like whether you allow them to connect to your systems or whether data is financial data play a role in the risk matrix. Nonetheless, there are some key questions that you should ask any responsible vendor that vendor should be able to answer upon request. For example, when you're talking about when you're scanning to do other things like looking to see who this vendor is, what information they're going to use, what is their reputation in the marketplace based upon what you're going to use that vendor for, you're looking at factors of risk. And oftentimes, at least in our organization, the information security provision is going to want to do a risk assessment of that vendor. As soon as they find out what it is, what kind of information they're going to be using, is it going to be PII? Is it going to be sensitive information that may be transferred? How the information is going to be transferred, and how long that information is going to be with that particular vendor. Oftentimes, information security is going to want to do what they call a risk assessment, which measures how the risk of using that information, how that information is going to be used. They generally want to know exactly what's going to be transferred and how long it's going to be there, and how it's going to be transferred and how it's going to get back to us. And in addition to that, the privacy area wants to do a data protection impact assessment or at least determine whether or not a data protection impact assessment ought to be done based upon the type of information, again, that's being transferred and the risk to consumers. As all of us privacy lawyers understand, that the main issue is what is the risk to consumer. And if there's a risk to consumer, then we would consider using a data protection impact assessment. The data protection impact assessment allows all of us to measure the risk in using this information versus the value in having that information. But it's very good because it requires the business unit to determine certain things like, do I really need this information? How much of this information do I use? How am I going to get rid of it? Who should have access to it within the organization? So the data protection impact assessment is a very good tool to help us, particularly if we feel that there may be some risk to the consumer because of the type of information that's being shared. Let's talk about some other things that you might want to do as well. For example, you also want to look at, begin a survey of the news to determine if there have been any recent incidents or complaints about the way this particular company maintains data or handles data. Even if the claims are unfounded, you will want to use it as a baseline for you to ask certain questions in order to proceed. I mean, lots of times in our organization, you know, ITS, the information technology contract person is going to ask the question, have you ever had a charge filed against you by some government agency? And we're going to look that person up to determine whether or not such a charge exists, or are there any lawsuits pending? They may not have any basis, but at least we understand, we have enough information to be able to ask a question about how did this happen, what is involved, so that we can avoid that situation for us. Also, a lot of times, our information security department, and we recommend that they do so, ask for a SOC 2 report, which an external audit has an external audit been done of that particular organization, and if so, we'd like to see a copy of it, or an ISO 27001, which governs information security, cybersecurity, and privacy protection from an information security management system approach. So, as much information as you possibly can to determine what type of vendor this person is. Who are we giving our information? Who are we giving our information to? What is this third party? What are their controls? What is the risk? Have they considered the risk? Now, let me talk to you about SOC 2 reports and ISO 27001 reports. If you have a large vendor, you're going to have they should have a SOC 2 report. I don't know any large vendors that don't have a SOC 2 report generally. If you have a smaller vendor, sometimes they don't have a SOC 2 report. But it depends on what you're trying to do with your information, or what information you need, and the necessity of this particular vendor. I have heard it argued, and I have said myself, if this particular vendor doesn't have a SOC 2 report, and we need this, and the business needs to use this vendor for purposes of processing this information, we may have to get involved and help them produce one. And that's not unheard of. Doesn't happen a lot, but it does happen. Sometimes we have to rely on other reports, other scanning reports, and look at their processes and procedures, and allow us to do an internal audit of them. That may not necessarily be an external SOC 2 audit, but an audit that's conducted by the business unit itself, just to get an idea of the safety of transferring personal information to this particular vendor. Of course, while no one can guarantee a system will be hack-proof, companies that are ISO 27001 certified or SOC 2 compliant provide a level of comfort to us, so that when we if there happens to be an incident that occurs, we can say that we used due diligence in checking to see whether or not that was a safe company. But I have some other questions I want to move on to, Lynn, and that is this. As you move to the contract phase, what are some of the key terms you think you should think about during contract drafting? We talked about having, I mean, once we've gotten through the SOC 2 and the ISO report, and we've done our background check, and we're getting ready to negotiate with this particular vendor, what are some of the things you think we need to think about at that point?
I think there are a host of questions that you should really be thinking about once you get to the contract drafting phase. I would say first, from a cybersecurity perspective, you really need to clarify whether the information should be stored on a local server or in the cloud. I raise this not because there's a right or wrong answer. I think the considerations vary on use case, vary based on your data sensitivity. I think that, there's some IT experts that are going to say a local on-premises server is more secure, while, cloud servers have flexibility and scalability. Depends on what is most important to your organization. Other things that you might want to consider is, whether that information is stored in the US or in other countries. I have talked with some, service providers, cloud service providers, who say that customers are insisting upon data localization. Data localization meaning their data being held within the country in which they are headquartered. We could do an entire webinar on data localization and sort of the drive around that. But essentially, the concern driving that is whether or not your information could be accessed by the government or law enforcement authorities of another country. For most companies, this is not a particularly significant issue, but for some companies it is. So if that is a factor for you, that is something that you might want to consider thinking about as you're drafting your contract. The other thing you want to consider is whether or not you want data to be contractually required to be encrypted in transmission and at rest. I'm sure that some of you who are in the privacy field have seen some of the recent data breach class actions filed, as a result of the large MOVEit breach that happened earlier in the spring. There have been some claims in these class actions that the defendants are breaching their duty of care by failing to encrypt data, both in transit and at rest. I will say, based on my personal experience, that we are mature enough in the sort of cyber realm that encryption is expected. Our regulators, both domestic and internationally, are expecting encryption to be a part of your business processes. So contractually obligating your service providers or your vendors to also utilize encryption might be wise. Does the contract require the use of logical access controls? For those of you who aren't aware of what this term means, but logical access controls really basically govern an individual user's access to data based on their role and their corresponding responsibilities. And so ideally, your third parties should be utilizing what we call the principle of least privilege, meaning that their employees really only have the access to the information they need to accomplish their specific job responsibilities and nothing more. I think we think about breaches and incidents often as, a malicious actor sitting behind a computer somewhere far away, hacking into a system. But sometimes it can be just an employee's simple negligence. Often it's an employee's simple negligence. Oftentimes it's also a very bored employee who has access to information in a system and they're just seeing what they can see. But nonetheless, that's still an incident. And so, contractually requiring that they are using the principle of least privilege, which should also come up in their SOC 2 and their ISO certifications, I think is a good idea. And, now that we're talking about, these breaches and incidents, I think it's really also important to specify what is considered a breach or incident and outline the notification requirements. And Mark, since you're in-house, and I know that, these are the kinds of things that people in-house are thinking about a lot, I wanted to sort of turn it over to you to tell us a little bit about, the breach and incident response requirements from the in-house perspective.
Sure thing. Well, as you know, all states have their own data breach notification laws. Most of them are similar, but some of them are a little bit different. And so you have to think about, what that means and what type of contract language you're going to put in your contract as it deals with data breach notifications. If you've ever been through a data incident or a data breach, you don't want to do it again. And so it makes you a little bit concerned about the language, because you find out that as much as you can put in the contract to pin down what steps should be taken, the better off you are, because you have to transmit you have to communicate all these things, not only to the vendor that you may be having an issue with if that particular vendor had a breach, but you also have to communicate these things to your own leadership and co-employees and maybe regulators as well. So what you can pin down is very, very important. More recently, the Securities and Exchange Commission promulgated regulations governing reporting requirements for publicly traded companies and requires reporting 4 days after the parties determine that a breach is material. That's an example of the kind of specificity I'm talking about. At least in the Securities and Exchange world, materiality, when they talk about what's material, the materiality threshold for cybersecurity incidents will be consistent with the standard analysis in securities law. The information, which is this, the information is material if there's a substantial likelihood that a reasonable shareholder would consider it important to investment decision-making. Also, the Cyber Incident Reporting for Critical Infrastructure Act includes incident reporting requirements for industries considered critical infrastructure. So let's go back for a second. One of the reasons it's important, as was pointed out by the SEC, is that we have to define what a breach is. And you know, what it is depends on what you can negotiate. It is. But you need to, number one, make sure you define what a breach is. Number two, make sure all parties understand what a material breach is. And number three, determine the timeline in which a vendor or service provider must notify a company when it suspects or has discovered that a breach or incident has occurred. Now, I ask you, and I don't want to go off on a tangent on this, Lynn, but I do. Unfortunately, I have been through some incidents that having to deal with this, and it was kind of special because sometimes vendors want to tell me that I'm going to tell you about a security breach as soon as practicable. What does that mean? I mean, is that 4 days? Is that 5 days? Is that a week? Is that 72 hours? I mean, what does that mean? So you may end up negotiating a couple of weeks over the question of, you know, what that means. Sometimes they use the terms immediately, which is not a bad term necessarily, because immediately, the standard definition of immediately means as soon as you know. But I think it's always better, and I know at least our InfoSec team and our privacy team generally wants to put a day on it or time. You're going to let me know within 72 hours of the time you find out that there was a material breach. Or in the best possible world, you're going to let me know within 72 hours that you suspect that any of my information, whether it be PI or other information that may be proprietary, was exfiltrated. I want to know. If you suspect my information was exfiltrated, I want to know within a certain period of time. And so I usually recommend that we try to put that time in there. Sometimes you have the bargaining power to do that. Sometimes you don't. But at least you should try. But what you don't want to do is you don't want to leave these terms undefined, because in the event of an actual disclosure or cyber attack, time is of the essence when it comes to reporting and when it comes to mitigating harm. And so I don't need to find out 2 weeks later. I have been in negotiation. I'll be perfectly honest with you. I have been in negotiation with a vendor, and there was a data breach that had occurred while I was in negotiations and was not told. It was, and there was provisions in the contract which said 72 hours, but they didn't tell me. Now, you know, obviously there's, you know what happened after that, but that's kind of what I'm saying. It does happen, and it can happen to you. It's happened to me. So I wanted to make sure that you understood that.
Yeah.
But it's also, I think it's helpful to clarify the roles and responsibilities in the event of a breach. And I'd like for you to address that, Lane, if you could.
Yeah, thank you for those insights. I think that's really important to hear from the in-house experience. I agree with you 100%. Suspect. When you suspect that my data may have been compromised, I need to know, honestly, within 42 to 72 hours. Because of the data breach laws, you need to know as soon as possible. So After foot stomping that, I just wanted to move on and talk about roles and responsibilities. Another thing you can do in a contract is really clarify roles and responsibilities in the event of a breach, really as a matter of preparedness and risk mitigation. As Mark said, what you really want to do is eliminate additional decisions. You will have a lot of decisions to make when a breach happens, and I'll tell you, people are not at their best when an incident occurs. It is a stressful time, whether it's a hack or whether it's simply employee negligence. Like, you may or may not have fidelity on what has actually happened. You want to eliminate as many of those decisions as possible. So you really need to think these things through. It's also a way for you to kind of limit exposure contractually, again, if you've got the negotiating power. Because, a breach is going to require an organization to engage in multiple steps all at the same time. They'll require a lot of coordination, communication up, out to the government, to regulators. There's so many things to do. So you've got to define which organizations are going to be doing what. The first thing you want to think about is a root cause analysis contractually required? It's absolutely going to be required for the vendor, but contractually, do you want to require that so that you have an understanding of what happened to your data? As a general matter, a vendor is not going to allow you as the client into their systems to perform that analysis, but you could negotiate the independent use of a forensic examiner. This will vary based on the vendor. I will say the reason why I like an independent forensic examiner is if you let the in-house IT team whose system has been breached do the examination, they're human. These are their systems that they feel like they have, done a good job protecting, and now it's been breached. It will be a difficult position for them to be in, to independently sort of examine their failures. So that's something that you want to think about negotiating. You also want to think about who's going to be paying the costs. If you can attribute fault for the incident or the harm, who's going to be paying the cost? Who's going to be paying the cost for the root cause analysis and all the associated costs? These are things that you really want to put into the contract, because that then helps you sort of scope down your exposure if possible.
Absolutely.
Yeah.
Go ahead.
No, go ahead.
I was just going to say, I certainly agree with you on 100%. And all of these things, I think you have to consider. And when I say these things, I want you to think of these things as you're negotiating your contract. These are the things that, if you play these things out, in the end, what do you want to see happen? And that's why Lynn and I are talking about them now as it relates to negotiating contract terms. For example, if there's a data incident that occurs, what are you going to do? And I think you need to think this out a while before you negotiate the contract, not after it happens, but before you negotiate the contract. What do you want to see happen? And does this contract allow for these things to happen? For example, in the event of a data incident, the first thing you're going to want to do, probably you're going to want to contact, if it's a serious data incident, you're probably going to want to contact your outside counsel. You might want to call someone like Lynn and say, Lynn, I got this incident that happened, and I need to step in and help us investigate it, because you want to protect, the privilege that you might want to have in your investigation. So generally, what is recommended is that you get counsel to protect the privilege by handling the investigation, and then it's protected by the privilege. So you get someone like Lynn and Finnegan to investigate and handle that. Then the second thing you're going to do, and you need to consider that in your contract procedure, the second thing you're going to do is you probably need to establish trustworthy communication with a representative of the vendor. Obviously, there's a relationship between somebody in the organization and the vendor. And at that point in time, the time of an incident, all the information you can get is very, very valuable. As Lynn mentioned, you have very little time. So anything you can glean, you try to have it. You put a provision in the contract which requires them to communicate with you in the event of a breach and gives you specific dates and times for them to do so. A third thing is obviously you're going to have to notify corporate leadership if you haven't done that first. And then you're going to have to get a factual update on the incident and determining whether or not there was PII, proprietary information, or sensitive information that might have been compromised. All of these things have to happen in a very quick period of time. And so if there's a breach, you're going to ask yourself, how will it be investigated? Will there be daily or weekly updates? Do you need to put that in your contract? And you add a provision which sets forth some procedure for those updates. You don't leave them to question. You make sure that there's a procedure for that to take place. And then you ask yourself what questions like, for example, who will report the incident to government agencies? What is the business's obligation to report versus the vendor's obligation to report in the event of an incident? Obviously, you're going to talk to your outside counsel about that. If you're in-house, it's probably not a good idea for you to try to figure that out without outside counsel who does this every day. But you're going to have, but those are some of the questions that you're going to have to ask. Those are some of the things that you need to make sure that you cover when you're considering negotiations.
Other things that you might want to consider is if there's a major incident, it is highly likely that you're going to be subject to some sort of class action. And so there will be litigation. Some instances I've seen where, a vendor and a client will try to do like a joint defense litigation. But then the questions come up about representational control and sort of control of strategy. If you're going to do a joint defense, how will you make sure that your company's strategy aims are incorporated into that litigation? How the cost going to be allocated? If you are now engaged in sort of independent litigation, if it is solely the vendor's fault, are you going to require indemnification up to a certain level? As Mark mentioned, there are going to be reporting requirements. If they are completing reporting requirements and they are discussing your data, is there a contractual requirement that you have the ability to review and confirm the information that's being reported out to government agencies or oversight bodies? And then finally, there are a lot of remediation activities that sort of come out of an incident. There are the remediation activities that are cybersecurity focused, where the vendor has to, fix their systems and close the holes. But there are also these privacy remediation activities. You have to, one, identify the universe of eligible people who's have been compromised. You have to provide them notices in the mail. You often have to establish a call center so that if they have questions, they can call somebody and ask questions. Who makes sure that the entire universe is properly identified. If they're eligible for credit monitoring, that they get that credit monitoring. And again, all of this comes with cost. Who is responsible not only for making sure all of these things happen, but who's responsible for paying for it? These are things that you can negotiate in the contract. It can be difficult, but depending on the sort of the nature of the risk, it becomes more and more important to negotiate all of these things up front. And then you might also want to consider whether or not you require the vendor to have cyber insurance. I think it is a good idea. Again, depending on the vendor, they may or may not have the capacity for it. But again, then that should impact the way you share information with them if they don't have the capacity for cyber insurance.
What I've seen, I'm sorry.
Yeah. No, go ahead.
I wanted to mention to you in that regard, Lynn, because often since I end up negotiating lots of data protection agreements, and I see lots of positions taken by lots of different vendors having to do with issues having to do with data breaches. Oftentimes, I see the vendor doesn't want to take responsibility for giving notice, let's say, for that. And if they do, they want me to pay for it, or they don't want to take responsibilities for hiring a professional to come in, and forensic examiner to come in to take it. And if they do, they want me to pay for it. And so oftentimes I find myself arguing over that. Cost of it, or even the fact that it can be done, or they don't want me in their systems at all. And so what I have, I'm not sure what you would recommend, but I know some of the things I try to do as a bottom line um, is to say, some of these things are required by statute. You may have to give notice because the statute requires you to give notice because of the nature of the breach. Or you may have to have a forensic examiner because it may be required. The cybersecurity regulations in that particular area, either the federal regulations or a particular state, may require you to do it. So I try to make sure, at the very least, that I put in a provision that says rather than not addressing it, at least I put a provision in that says if required by law, so that they have to do it if required by law. And so I found I had to find a way to do that. When I first started doing this, I didn't know enough to know how to do that. Obviously, like none of us did when we first started doing it. But as the years pass by, you find a way to fix that. And I think if you put in a provision that makes sure that they have to follow the law, sometimes you can cover that without going through a lot of negotiation.
That is a very good technique, because honestly, the notification requirements, as you mentioned, are dictated by law. In some states it's 48 hours, in others it's 72. And I think as required by law is a great way to just get them to acquiesce, because it's required by law. It would be unreasonable for a vendor to object to that.
So let me ask you this question. Let's switch gears for just a moment. Many of us may be aware that the California Attorney General released an enforcement decision against makeup company Sephora. I read the complaint. It's interesting. There were lots of allegations in the complaint, but relevant to us today was the allegation that Sephora did not have proper contacts with third parties it was sharing information with. So if you don't mind, I'd like for you to, how should we be drafting contracts in light of this enforcement decision? For example, what does a CPA require?
Yes. So if you have a relationship with a third party, if you're sharing data with someone, if you have a properly drafted contract, then it will not be considered a sale of data. And so I want to get into, like, what does it mean to sell data? So the statutory definition is very, very broad and wide ranging. It means selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally, in writing, or by electronic or other means a consumer's personal information to a third party for monetary or other valuable consideration. So that's a really, really broad definition. And what we saw in that Sephora decision, on that settlement, was that the state of California found that sharing customer data in exchange for analytic insights, not actually money, but that the analytic insights about their customers constituted valuable consideration and was therefore a sale of data. And so, as I said, like, when these relationships are within the confines of a properly drafted contract, then your relationships with third parties fall outside the scope of a sale of data, which then eliminates many of the compliance requirements of the law. But if you don't have a proper contract, it is going to be considered a sale, which then means that you have to do some additional compliance requirements. For example, this isn't comprehensive, but you might have to do things like, one, put a notice on your website that you do sell data. You have to offer multiple ways to opt out of the sale of sharing of data. If people, have a global privacy control on their web browser that basically says, do not track me, do not sell my data, then you have to have the actual technical capacity to do that. So really good contract drafting can help eliminate some compliance requirements, if done properly. So I really want to sort of get into what the contractual requirements under CCPA are. I know that this slide is very text dense. The reason why it's so text dense is because, I want you to have this as a reference later that you can take a look at and go back to. There is no need to try to read this all now. I'm going to give it to you at a high level. And then as you go back later, you've got the exact text. But as an initial matter, all contracts, whether or not it's a third party, a service provider, contractor, any contract that someone's doing business in California has, they've got to specify the personal information that's going to be sold or disclosed under the contract. And if you recall, when Mark was talking earlier, you heard that in Colorado's terms. Other states as well are sort of modeling this framework where you really need to be specific about data in your contracts. The contract also has to require compliance with basically CCPA and its amendment CPRA level protections. The contract has to give you as the business the right to take reasonable and appropriate steps to ensure that your information is going to be used in a manner that's consistent with the contract. It requires your third party to notify you if something happens and they can no longer meet these statutory requirements. And it gives you as the business the right to stop and immediately remediate any unauthorized use of personal information. Now, the statute also specifically defines the terms contractor, service provider, and third party. And the definitions of these parties are really relevant to how the contract must be drafted. So I wanted to get into what a service provider is. So a service provider is a person or an entity that's going to be receiving and processing information on the company's behalf. So this is going to be someone like if you outsource your payroll function, they're going to be processing your HR data so that your employees can be paid. If you have a service provider, they have to be contractually prohibited from selling, sharing, retaining, or disclosing that personal information for any other purpose except as defined by the contract. They also have to be contractually prohibited from combining the information that it receives from you with any other information that's gotten from other customers or information that it already collected directly. And I highlight this because this is not an accident. This term and this requirement is specifically designed to prohibit cross-contextual and behavioral advertising. So if you are a company that wants to share or hire a vendor to engage in that kind of activity, by default, it cannot and it will not be a service provider. It will not get the protections from the sale of data. That is something that the state of California is very, very focused on. If your service provider utilizes a subcontractor, then your service provider has to require you as the business that they've got a subcontractor, and that subcontract has to mirror all the privacy terms of the privacy contract. They're also contractually required, subject to agreement, to allow you to monitor compliance with the contract. And this can take a lot of forms, manual reviews, technical assessments, audits, but in the contract, you need to have that option. For a contractor, I'll move through this quickly, but it's essentially the same requirements as a service provider, but a contractor is someone who has access to your data, but they aren't actively processing the data. So think about this as like if you had a consultant come in to assist you with strategy development. That's who your contractor is going to be. They have the same requirements as a service provider, but they're also required to certify that they understand the restrictions and comply with them. And then the last is a third party. And, it's very interesting that a third party is defined in the negative. It's someone who is not a service provider, who's not a contractor. So who these people are the people that you are usually selling your data to and providing that data to for a business purpose. If you have a third party, they are not likely to be exempt from sale. And finally, it's very easy to be excited going into an agreement, but all the good things to come to an end. So what should we be thinking about as we come to the end?
Well, one of the things we need to start thinking about, Lynn, is once we've gone through the process of talking about, we've investigated the vendor, we've considered data breaches, we've considered the use of personal information and how it's going to be transferred and whether it ought to be protected a certain way during the process of that transfer. And now we've gotten to the point now of we're through all of that. They processed our data. They've performed the services that we need to have them perform. We ask the relevant question of how will our data be returned? How will we get it back? How long will they keep it? Is everything straight once the relationship ends? One of the things it might be worthwhile to do in answering that question is to work with your chief information officer or your chief information security officer and ask whether you should require deletion up to a certain technical standard. Because as lawyers, we say, I want this deleted, but we don't know what that means. So we go to our CIO, particularly me, and normally I would go to the Chief Information Security Officer and say, I want this information deleted, and I want to delete it in every possible way I can have it deleted, because the statute does not specifically tell me how it's going to be deleted. It just says I have the right to have it deleted and should exercise that right. So I need to talk to them about that particular area as well. So I'll talk to so I suggest that you talk to the CISO or talk to the CIO about the possible standards of deletion. And then you have to ask yourself the question, if there are laws requiring data retention for specific periods of time. For example, if you're involved in telecommunications and you have a call center, you may be in, there are certain state regulations which require you to keep call center records and solicitation records for a certain period of time. Some states 3 years, some states 5 years. I think there's one state maybe 5 years, some states mostly 3 years. So notwithstanding the fact that you want your information deleted, it may require the vendor keep it for a certain period of time, notwithstanding what the CCPA says or what the CPA says or any other state statute related to privacy. There may be another corresponding state statute which requires them to keep that information. So you have to make that decision and decide that, and make sure you put the language in the agreement that specifically excludes that type of retention. Now, I'll say to you, just because they're able to they're required to retain certain information for a certain period of time because of a specific statute, make sure that you make an exception only for that statute's requirement. Don't leave it there forever just because you have one statute that says you can keep it for 3 years. Make sure you specify that if the Arkansas Charitable Deductions Act says you have to keep you must keep this information for 3 years, then you specifically say that in the contract. Make it as narrow as you possibly can. So I guess the question I have is this, Lynn, and I can tell you what I've done, but what do you do when you have conflicting statutes? One of them that says delete it now, and the other one says keep it for so amount of time. How do you handle that? What do you think about that?
I mean, I think as a matter of law, you cannot delete if you've got another, statute requiring you keep it for those purposes. But what you can do, what I would do is, as you said, state that, you are legally required to keep it for this period of time pursuant to X law. And upon expiration of that retention period, the company must delete this data and must certify that they've done it as required under the contract.
Right. Thank you. And then that raises another question of that is have you specified in your contract the relinquishment of equipment or of system access and data to ensure that you don't have residual risk from an entity that you no longer have a relationship with? For example, you have a processor that you have a relationship with, and you're going online to have them process your work, and you find out 5 years later they had a data breach, and your work was still there, and you thought it was long gone. You have to make sure that you have language in the contract that guarantees that level of deletion has occurred before that happens, to not allow that to happen, and require certification of all wind down activities. One of the things that's important to me, and it always has been important to me, is that when you wind down a contract, you have a wind down agreement. You sit down and talk about it. You have a specific agreement that that in our organization you have a specific agreement that when the information is when the relationship is over, it tells you who's going to do what and when they're going to do it and how they're going to do it, and everybody signs off on that particular wind down agreement. So that even if there's something that wasn't specifically mentioned in your main master services agreement or statement of work, that wind down agreement might cover you and keep you from having a problem with something showing up that you didn't expect. And then the question becomes also, when will the information be deleted? And who's going to delete it? If it's on the vendor systems, obviously the vendor is going to have to delete it. But sometimes the vendor tells us, well, guys, you put it on there and you can delete it off. So the question becomes, whose responsibility is it to delete it once it's there? Is it their business? If it's a cloud product, is it the business's responsibility? Is it our responsibility? That ought to be in the contract. That ought to be discussed at the time you talk about entering into a relationship with that particular organization. And then one question I mentioned to Lynn the other day that's interesting. That if you're in-house, you probably have heard this question. Who's responsible for deletion within the organization? Is legal responsible to make sure that this information ought to be deleted with this particular vendor? Although legal, and because legal negotiated the contract, but legal didn't transfer the information and has absolutely nothing to do with the use of it. So is legal responsible for making sure that the information is deleted? Is the business unit responsible for it? Is InfoSec responsible for it? Is information technology responsible for it? Is compliance responsible for it? Is the privacy officers responsible for it? The question in my mind is, who's responsible for that? And is there a policy or statement of procedure which addresses that, which is the most important question? In your organization, I suggest that you get with the privacy office and figure out who's responsible for making sure that this wind down procedure takes place, the information is deleted, that InfoSec has been notified of that the information is going to be deleted, and to their to their satisfaction, it has been deleted off their systems. And who's responsible for keeping up with that timing? I think that's extremely important. That's something that's often overlooked by companies.
Well, I know that we are running close to the end of our time, and I know that we wanted to leave questions from the audience. Again, thank you all for joining us today. You know, there's a significant intersection between privacy and cybersecurity and contract drafting. And again, while you can't be 100% sure that a vendor won't have an incident, at least asking these questions and drafting your contracts with these things in mind can help you better manage your risk in this sort of new, exciting world.
We have one question in the chat. How do you suggest we respond if the vendor refuses to release the SOC2 or the ISO 27001 report?
I would say that is not a good sign. Mark, you please chime in here. If you've got a vendor who, will not release those reports, that to me says that maybe there's something that you should be concerned about that's in the report. So Mark, I turn it over to you.
I would say you're absolutely right, Lynn. That is not good. That won't happen. It's one thing, KJ, if they don't have one. If they don't have one, then we can try to talk about methods we can get with information security and talk about methods because what we're talking about is making us feel secure in transferring our information back and forth between them. So there are other methods. There may be other methods if they don't have one, but some of the statutes require that the processor shall allow for audits and inspections by the controller. So if I go, for example, and say, well, the Colorado statute says I get an audit and inspection under the statute, and you don't have one, so are you going to let me audit you? And that's when it gets in the question. Remember when I mentioned before, sometimes the need for the services is such that we may go ahead and do an audit of that particular vendor to guarantee ourselves that they're safe. But my initial reaction with Lynn, from a legal standpoint, from a privacy standpoint, that is concerning.
Yes, it probably means that you need to look at other vendors if they are refusing to share their documentation.
They have it and they're not giving it up. That's not something I would do, probably.
So we have a couple more questions and a few comments. And before I read them, I just want to remind everyone that you can enter your questions in the Q&A module on the platform, and we will get to your questions as time permits. One question is, you mentioned that using a third-party vendor for analytics is considered a sale in California. Is this the same for something like Google Analytics if you are just using them to see how people navigate your website?
I think it would really sort of depend on sort of what the terms of Google Analytics are. Are they taking your website? Are they allowing you to engage in targeting across websites? If so, then that is going to be considered a sale. It means that if you are able to take behaviors of your consumers, have it aggregated and do intentional sort of targeted marketing, that is what the law is designed to exclude from protection, and we'll consider it a sale.
Other than the due diligence you eloquently outlined, is there a preliminary data privacy risk assessment process you recommend apart from the InfoSec risk assessment?
Mark, would you like to take this?
Sure. Yeah, what I recommend is three things. One is doing a Google search. I mean, doing a search. I mean, the broad search that you do for a vendor to look to determine whether this person has been involved in anything any legal matters, any publicity that's not favorable. And then the second thing is the information security risk assessment, where they go through and figure out what risk is taken, what the risk is for this particular vendor. They have a detailed questionnaire, and they look at, how much information they're going to have, where they store it, what are your rules, what are your regulations. They're going to want to see a SOC 2 report, and it's a fairly detailed report if we're going to exchange personal information with that particular vendor. And then the third thing is a data protection impact assessment, which is really a weighing out, so to speak, of is this particular area worth the risk. It's different from a risk assessment, because a risk assessment is very technical and looking for information security things. The data protection impact assessment is weighing out how much should we even engage in this project? How much information do we have? Should we give all of that information? Should we only give a portion of that information? It gets more detailed, and it involves a business unit. It involves legal. Ultimately, it's a legal question to weigh out the risk. And so those are the three things that I recommend, particularly when you have sensitive information or information that may put the consumer's data at risk.
And I think we have time for one more question. For CCPA contract provision requirements, what about the additional contract requirements included in the CPRA final regulation, section 7051?
I'd have to pull that section up particularly. Did they give you any more context about?
No, that was it.
I'd need to go and actually sort of take a look at the regulations to answer that one.
All right. I think those are all the questions that we have. So thank you to our esteemed panel for an amazing presentation. And thank you again to Finnegan for making this possible, and our continued valued partnership. While on the subject of cybersecurity and privacy, we invite you to join us March 25th and 26th at the University of California, Los Angeles for the 2024 ACC Foundation Cybersecurity Summit. This conference, the premier legal cybersecurity conference in the United States, offers 2 days of impactful educational sessions and strategic networking opportunities designed to enhance your understanding of cybersecurity principles, threats, and strategies, enabling you to become a more effective, well-rounded, and well-connected practitioner. We invite you to register today at the QR code that's on the screen and use code WBCST1011, which is also in the chat, for a $50 discount off the registration fee. I hope to see you there. Thanks to all of you for your time and your support of the ACC Foundation. This concludes today's webcast. Please enjoy the rest of your day.